You are on the record.
Well, good morning. Today is the 10th day of July. The time is 9 o'clock. The Board of Commissioners is in session to conduct a Board of Equalization. All three commissioners are present. Are there any changes to the agenda, Mr. Clerk? Any changes? Okay, no changes to the agenda. Okay. All right, we're taking up the appeals on the tax exemptions. The first item we'll take up is parcel number R101-300-5667. That would be the First Presbyterian Church. Okay, so we'll hear from you first, and then our lawyers will give a.
Thank you. Good morning, Commissioners.
You have
I
10 minutes.
appear before you again this time on the 2025 tax exemption appeal. We've been here before on the same record and the same issues essentially in 2024 and 2023. I don't want to waste your time. I know you've got plenty to do. So what I would suggest, as I assume you've been advised by your excellent counsel, Mr. Berry, that the Supreme Court heard oral arguments on the 2023 appeal on June 30th. Very active and interesting questioning from the justices. 4 were on the bench. The chief participated in via Zoom and is going to participate in the decision. Of course, the Supreme Court operates on its own timeline, and we expect to get a decision. Hopefully, 3 to 4 months is somewhat typical. So I think that's going to be the ruling that would govern that case, as well as the 24 case, now stayed in the district court because of the pending Supreme Court appeal ongoing in the 2023 exemption. And I assume you will do the same thing you have done in those 2 cases. In this case, obviously, the church is appealing the 82% partial exemption that's been granted and seeking the full exemption based upon both the statutes, Idaho Code Section 63-602B, applicable to religious entities, and also under 63-602C, applicable to charitable entities. You have made your prior decisions on the religious exemption statute only and declined to address the alternate ground the church has asserted for some unknown reason. But with that, unless you have questions, I have nothing further to add. We'll wait for the Supreme Court decision. On the 23 case, I assume that will be considered controlling law and dispositive of that year. Also, the 24 exemption, same facts and record, same law involved, and also on the 25 exemption now before you. Same facts, same record, same law, except with some updates as to what the square footage of market rates are in the subsequent years, not in the 23 record, but added in 24 and 25. So with that, I have nothing further unless you have questions.
The only question I would have is relative to the Supreme Court decision. Are they going to disavow the Sunny Ridge factors?
Your guess is as good as mine, Commissioner Beck. We don't know what the Supreme Court's going to do until their opinion is out, and anything would be speculation
when they
on my
consider
part.
when they consider a case, they typically don't overturn a prior case; they just disavow it.
Well, I've read a few Supreme Court opinions in my 40-plus years career, and sometimes you're surprised, sometimes you're not surprised. Sometimes they go in the direction you expect, sometimes they do something completely different. So how and what they'll do here, I have no idea. I would suggest this case is quite unique insofar as it's got a partnership of the church and a charitable organization working together and highly subsidizing this daycare that affects 165 kids and providing discounted daycare so that the parents can work. One of the interesting questions I found from one of the justices is posed to Mr. Berry, I recall, is that, well, is the county actually going to be in a worse position if they recover the $28,000 tax on the 18% being levied on the church, or are they better off because of the daycare, the parents are able to work and earn income and support property taxes and buy homes? And so I guess that's a different decision, but I found it to be a very interesting question.
All right, any other questions from the board? Go ahead.
Do you think this decision will set a precedent for similar cases down the line?
Well, again, the courts decide a case on a case-by-case basis before them, but they undoubtedly take into consideration larger factors as to the impact on a wider scope and community. So, it's certainly possible that this would be considered precedent, or some of the discussion and issues might be, but I really think this is a unique situation. The other cases that have been cited in the briefing and discussed over the years with you by both sides and with the Supreme Court briefing and discussed with them suggest no other case where there is this partnership of a church and a charitable organization to subsidize and operate a daycare. So, if we limit the decision to those facts, then I'm not so sure it would have wide-ranging impact. It may just be, this is a unique case, and in this unique circumstances,
Well, we've definitely had a few that we have to decide each year where it does seem a little bit similar, where you have one charity or a church leasing space to another charity or church, or some combination like that. As you probably remember, I did vote in favor of your appeal prior to your going to the Supreme Court. I thought we were being a little strict on our interpretation, but I think in my mind, it's in certainly the spirit of the law that the legislature came up with. If the goal is to facilitate charities and churches to do their mission, I think that then we're within our rights to grant the exemptions, but certainly some clarity. Because I think some of the times it's being interpreted, it's kind of on the strict language as opposed to the spirit, which should be to, allow charities to do their mission without being assessed property tax. Just that extra component of, leasing from one to the other. It seems to be what we get stuck on. So yeah, I think it would be great if we could get some clarity on that.
I appreciate your comment and the sentiment. And I don't agree with the characterization of a lease. We had a shared use agreement. We continue to have one. And I think overlooked in the discussion, although I've attempted to communicate it, is the idea that this is not done on a market level basis, the amount of money the church receives from the Y. And that's my understanding of what the old Idaho Board of Tax Appeal decision in 2020 or 2012 relied on. And I find it completely distinguishable and not good precedent. And comments from one of the justices suggest to me that they don't care about the IBTA 2012 decision either, whether it was for that reason or some other reason. But it is the province of the court and the Supreme Court to state what is the proper interpretation and application of the legislature's statutes, and to do so in a situation as here, where the facts are clearly undisputed, is something that is their job. So there's been difference of opinion at this level. There's been difference of opinion with the district court in the 2023 case, and that's why the Supreme Court exists, to declare what is the law. That's their job, and to apply it to the facts of this case. So that's what they will do, and I do think it'll be controlling and dispositive in 23, 24, and 25, and in the future with respect to the First Presbyterian Church and its tax exemption status as either religious and or charitable going forward, assuming the facts remain the same or similar as I expect they will do at this point. So with that, I thank you.
Okay,
and,
thank you. Any other questions?
No question, just a comment and follow-up in terms of what we're saying here as well. And I think this is an example. Our system of government that our founders gave us was to go through a process that we're going through and have the various levels decide, talk, et cetera. And Federalist Paper 51 was a perfect example of that when the Madison and Jefferson said, pitting ambition against ambition, and then finding a resolution of it at the end when that ambition against ambition. So no one part takes total control of our system. And so what we're going through right now, we're making a decision based on what we have and the facts we have, goes forward, and then it's decided, as you just mentioned, through a process that is a good one. And when it comes to that, we will abide by that decision as well, whatever it is, and go forward. And the legislature also can step in if they decide they want to change what the Supreme Court said. So that's our process. So thank you, Mr. Chairman, and I.
All right, does council have anything you want to add?
No, Your Honor. No.
Okay, no, I'm not. Okay, thank you. All right.
I'll just follow up with that on, I would say no matter which way the court goes, that I think I would support the legislature taking a look. I think they always have to review the process and the statutory tax exemptions, but it's always possible the legislature could fix this and bring a little bit more clarity. If that is what the legislature wants, where to facilitate charities and churches to do their work without being taxed, they could look at that factor of leasing, or I know our attorney here is saying it's not a lease, but in general, the leasing space for, I guess the issue is whether they're profiting from the space versus just paying the expenses, but certainly the legislature could clarify some of that. With that, I guess I would make a motion.
What's your motion?
My motion would be to move that the Board of Commissioners, sitting as the Board of Equalization, uphold the partial percentage of the tax exemption for First Presbyterian Church on parcel number R10130056667, as listed on the agenda, and authorize the chair to sign the documents on behalf of the board.
I second the motion.
Okay, you've heard the motion. Is there any further discussion? I would only add, I don't think the legislature will really care what we think. They'll just go ahead and do what they want to do anyway.
I would just note that I didn't hear the 82% in there, and I'm assuming that's what you're voting on, and you might want to clarify.
I thought you did. I thought
I
you
did
did.
not say 82%, but I will clarify that the Board of Commissioners, sitting as the Board of Equalization, uphold the partial 82% of the tax exemption for First Presbyterian Church as listed on the agenda.
And
Re-second.
I re-second that clarification.
All right, well, you've heard the motion. Any further discussion? Hearing none, all in favor? Say aye. Motion carries. Thank you.
Thank you, may be excused.
No, you got to stay for the whole hearing. No. All right, thank you.
Nice to see you
Thank
all
you.
again.
Thank you.
Okay, we'll now next take up parcel number R3226110022, Grace Bible Church. And we have some, could you identify yourself?
Yes, Mr. Chair. My name is Jason Mao. I'm here on behalf of Grace Bible Church of Boise. With me is Pastor Joe Cassiopo here he's here to, he's not going to present anything, but he did want to be here in case there were any questions related to the facility that you would have.
Go ahead.
All right, well, thank you. As I state, my name is Jason Mao. I'm appearing on behalf of Grace Bible Church of Boise, Inc. They've asked me to help them with the appeal here of the partial denial of their property tax exemption. As my narrative that I sent in with the appeal form goes over, we believe that the church is entitled to 100% exemption here. And And I do recognize that the First Presbyterian Church, the first here on the agenda, does weigh heavily in a lot of these decisions going forward, because as was stated before, that was before the Supreme Court. I would ask that you look at this one in a little different way, but I recognize that you may be looking for some direction as to the partial uses here, and we believe that the use here is a little different than in that case. But otherwise, this case, we have only asked for an exemption under 602B. I also point out 63-602 sub 2, which defines exclusively and exclusive as used in these statutes, which means that the use is exclusive for anyone or more or any combination of the exempt purposes in this chapter 63. And the property is used for more than one exempt purpose provided for in those statutes. And here, as the materials that were provided, it does, the Grace Bible Church of Boise was incorporated for religious purposes, of course, but also for charitable and educational purposes. We believe that the partial exemption was ordered here because of the use by the school here, and that there was money involved. They did ask for the school to cover its charges for use of this building for these days. But the use here is related to the same educational purposes of the church. There is Christian education that's involved in this, and so there's some similar purposes there. And because of that, we believe that it is allowed for a 100% exemption here. And I think the statute 603 or 63-602B, it focuses on the purposes of the property owner and their use of the property. All of the property use of Grace Bible Church is related to their purposes. If the purposes of this school was not related to that, they would not allow this school to use those classrooms. And so because it's the purpose of the church that's involved, we believe that it's entitled. I also left in another argument as to the second part of this statute, which I think in a lot of the cases in a lot of the counties, we have appeals beyond, I know there's appeals going beyond First Presbyterian, as I'm involved in on this statute regarding Christian camps in Valley County and Custer County. But none of these counties have stepped through the whole statute and looked at that last part as well. That states that provided that, even if there's money, even though fees are charged or imposed or revenue is derived from a certain use, if it's used for athletic or recreational facilities, residence halls, dormitories, meeting rooms, halls, auditoriums, club rooms, for and in connection with the purposes of the religious organization. And notice here that it's not exclusive use here. The wording here is in connection with. So there's even here the use of this school for their auditorium, for their meeting rooms, for them to be able to come and meet is in connection with the church's purposes. And so I think even though there is money exchanged because it helps cover the cost for them turning on the lights during the week on these 70 days that the school uses this building, the argument there is, of course, that the statute would direct us that the church is still entitled for 100%. My last argument, and I won't get too much into it because I know a lot of these counties are probably waiting for just direction on the statute itself, but I question whether the questions that the counties asked in these long form applications, which was given to our our client after they filled out the short form for additional information. But when they ask these churches whether or not there's a commercial or business purpose, I forgot the question that's asked, but it's whether or not those, or if they let another organization use it in part, and whether or not that is used for a commercial or business purpose. When these religious organizations say no and give the information that shows that it isn't a commercial or business purpose, I wonder to what extent that is kind of the overreaching. We get into First Amendment issues between the government entities looking closer at that, and whether they're taking those answers on these applications that have been certified to the commissioners as bona fide or bona fide, and the actual use, and whether or not that is questioning what these religious organizations are doing. And that may be maybe with the Supreme Court giving clarification on the application of this statute may not have to go that far, but I think that's a relevant question when this statute is focused on religious use of the properties and a religious organization. Otherwise, I guess in the very end, if the commissioners still wish to uphold their decision and wait kind of for what comes out from the Supreme Court on First Presbyterian Church, we would just ask that the 85% be altered because, and here you asked the wrong guy to do math here, but these are only 6 classrooms that are used for 70 days. And sure, 70 days out of 365, I can see maybe where they're getting 85%. But beyond that, they're not turning the entire church over to this school. The church's business, the church's ministry still goes on during those times. The school does not have full range of all the offices and everything. They've asked to use auditorium, halls, six rooms and bathrooms, of course. But I would say that we would ask that if they are still going to go to partial denial, that they consider that it be 93% and not 85%, because, and I just took the 15%, or actually the 75 or 70 days out of 365, divided that, and I think you get to 15%, and then divide it by, I forget what I divided that by, but then like half of that, around half of that, divided by days, divided by the percentage of the church, and I came to 6.6% that's actually used out of the whole year of this facility, and so that's where I get to the 93%. So with that, if you have any questions for me or from Pastor Joe regarding the use of the property, we are more than willing to answer.
Okay, I guess one question is, you're not asking for an education exemption, you're asking for a religious exemption, correct?
For a what?
A religious exemption.
Correct, and the religious, the statute states that it's for religious, educational, recreational purposes, and all of those purposes fit in with our purposes in our organizing documents. And then, and that's why I pointed out 63-602. If it's any of these exempt purposes, we can use those to show that we're entitled to full exemption. So I think all of our purposes are related to all the purposes that the school used for it. We don't have to just stick to the religious exemption here, religious, education, recreational, and then even broader in 602 too.
Okay, any other questions from the board?
Mr. Chairman?
Yeah, go ahead.
So I guess I had part of the question that the chairman just asked as well in terms of the educational. You're blurring the educational and the religious part. So you still want to stick with just the religious, that section?
602B, correct. We've filed our application under that.
Because you're
Correct.
saying that is encompassing the educational component. So I guess my question then, Mr. Chairman, is why did why did you, it's a couple of prongs. Why did you decide to do this educational component that you haven't done before? And then how many individuals that are parishioners at the church actually participate in the educational component?
Yeah, and I think if you allow Pastor Joe to answer that, I think he would be able to answer that better than I.
Can you repeat that?
How the school is using the church. How many people that attend the church also go to the school or use the school?
In the school, we probably have I think we have 12 students from our church particularly. All the students come from churches though that we associate with, and, you know, that's one of the prerequisites of being able to attend the, the school program. Specifically, our church, 12, all of them, though, do attend churches that affiliate with us, that we, would affiliate with.
Okay.
Go ahead.
And as a follow-up to that, what prompted you to expand? I'm assuming you have a Sunday school as a component of your regular services,
Yes.
regular church part. What prompted you to expand it to beyond the normal religious Sunday school type educational component of your church?
Well, we've always had a type of a school that works with, this school works with parents that are homeschooling.
Okay.
That's specifically what it's doing. We in the past have done that on our own. Found it to be a burden for us, not knowing exactly how to do it well. We found a organization that knows how to do it better than us, and was needing a place to do it. And so it's not, it's a new venture, but not a new venture. It's always been part of our goals as a church,
Mr. Chairman?
Go ahead.
So clarification. So my understanding of what you just said was you're amplifying your parishioners, your people who are attending your church and other churches, the ability to participate in an educational setting, either it's homeschooling or just supplemental to the regular schooling as part of their
Right.
educational component, religious educational component. Does that kind of clarify? Try to clarify in my mind why you're doing it separate from your normal religious education on a Sunday or other days of the week that you use the church for religious education.
Because we
In
do
other words,
things.
why did you start the school as separate from your church function itself?
It's what I said is that we've always had a more than just a Sunday morning function to our body and to other people that wanted to be part of it.
Okay.
All we've changed is that we are letting someone else run it, someone that is better at doing it than us, and so we, it's, we don't see our ministry, we would call ministry our goals, as just Sunday morning. We're always involved in every aspect of our body's life, family's life.
Thank you. I think you've clarified. That was my question: is
Yeah.
the separation versus the togetherness of your religious function. Thank you.
Okay. Any other questions? Thank you.
Thank you, Commissioner.
Okay. Did you have anything you'd like to add?
I would only add that, at this point in time, you as a body of the BOE really don't have jurisdiction to consider the constitutionality of this statute and what you require. That would be raised on appeal. So you don't have to consider that in your deliberation.
Okay, all right. Okay, do I have a motion?
Mr. Chair, I'll move that the Board of Commissioners, sitting as the Board of Equalization, approve the appeal and grant Grace Bible Church of Boise Incorporated a 100% exemption based under Idaho Code Section 63-602B for parcel number R32261100022, based on the testimony provided, and authorize the chair to sign the documents on behalf of the board.
Mr. Chairman, I would second that motion because I think they have clarified in my mind their religious educational function as a component of a total in terms of their explanation of how they use the building for educational / religious functions, and I think they're intertwined. So I would second the motion.
Okay. Okay, so the motion is to grant the 100% exemption.
Yes.
Okay.
Mr. Chair,
Yes.
I would say that based on the testimony I've heard, that the church has demonstrated that the school, the educational part is also a part of the religious mission of the church, so that the educational part does fit under the umbrella of a religious exemption.
Okay, you've heard the motion. All in favor, say aye. Aye.
Aye.
Motion carries. Thank you. Okay, we'll next take up, parcel number R10130091181, Elks Rehab Center.
Good morning, Mr. Chairman, Commissioners Davidson and Daly. My name is Daniel Fredrickson. I'm appearing on behalf of Idaho Elks Rehabilitation Hospital, which I'll refer to as the Elks. As you may know, the Elks is an Idaho nonprofit corporation with deep ties to Ada County. It was actually started in 1947 as a medical facility for children with polio, and then developed into a full-fledged rehabilitation hospital that operated for decades right off of Fort Street here in Boise. And that operated until 2014. The Elks now administers an endowment fund that it uses the income from that endowment to donate millions each year to provide rehabilitation services in Ada County and throughout Idaho. So that's a little background on who Idaho Elks is. We're here today because Elks is appealing the denial of a property tax exemption application on one of its buildings. Its office building, which is located at 100 West State Street in Boise. And put simply, the basis for our appeal is simply that the Elks is a charitable organization, and it uses its office building exclusively to further its charitable mission of providing rehabilitation services to Idahoans. Now, I want to be clear, Elks has historically received an exemption on this property under two statutes. One I just mentioned, the charitable exemption, section 63602C, and then another statute, Idaho Code section 63602D, the hospital exemption. I just want to clarify that we're only seeking on appeal an exemption under the charitable exemption, 63602C. And we've, now before, and so in that regard, I wanted to start kind of what I had planned today by addressing the board's denial because we were kind of at a loss for why Elks was denied an exemption, a charitable exemption on this property. I brought copies of the letters, if that would help jog your memory. Could I provide those to you?
Sure.
Thank you. So I just want to focus on the highlighted part. It says the application did not contain sufficient information to prove that the property is entitled to a charitable exemption under section 63602C. So I guess I just wanted to provide you an opportunity if you were looking for additional information or what our application was missing that led to the denial. I would be happy to, provide further information now. But I don't want to put you on the spot, but if there's anything I can do to answer questions now before I get ahead of myself. If not, I can continue with what I had planned, but please interrupt me.
Okay, go ahead.
So I wanted to focus the rest of my time just on providing an explanation for why Elks in this office building qualifies as tax exempt under 63602C. It's a two-part test under Idaho law. I'm sure you're well familiar with it. The first, Elks meets both parts. The first part is the entity applying for an exemption has to be a charitable organization. There's an 8-part test. You already mentioned it, the Sunny Ridge factors. Those are good law as far as I'm concerned. They haven't been overturned. And I want to briefly touch on each factor. Please interrupt me, though, if you want to focus on one. The first factor is the entity's stated purpose. The Elks Articles of Incorporation state that its mission is to support the delivery of quality inpatient and outpatient medical rehabilitation services to ill, injured, or disabled persons throughout Idaho, to promote education and training of medical and paramedical personnel, to advance medical knowledge concerning disability, and to support research concerning the management of the disabled. I think that's clearly a charitable purpose. The second factor is courts consider is the charitable functions that the entity engages in. And here, like I said, the Elks mainly serves the community by administering the Idaho Elks Rehab Endowment, which donates and grants millions of dollars to Idaho not-for-profit medical providers throughout the state to further rehabilitation services. And so in fiscal year 2023 alone, Elks gave $2.5 million to Idaho not-for-profit medical providers. And I've detailed all those donations for the past 2 years in my appeal narrative. This is my first property tax appeal, so I don't know what you guys have seen prior to the hearing, but I could provide you with the appeal narrative if you don't have it. Would you like a copy?
We've got it up here.
Okay, great. Then I'll just carry on. So some of those donations, for example, Elks gave $10,000 to the Bonner General Health in Sandpoint for treadmills and exercise equipment to use in its neurological and orthopedic patient care center. It gave $10,000 to Idaho State University in Pocatello for its PT students to use and the patients they work on. Locally, it gave $350,000 to the Boise's only pediatric hospital, the Idaho Elks Children's Pavilion. That's part of an ongoing $5 million multi-year donation to that facility. And it gave over $2 million to the St. Luke's Health System, just to encourage St. Luke's to expand its rehabilitation services. That was just fiscal year 2023. Fiscal year 2024, Elks gave another $3.2 million in donations. And once again, these ranged all over the state, but the bulk fell largely in Ada County. For example, it gave $75,000 to Minidoka Memorial Hospital in Rupert for its recovery rooms. That's part of an ongoing 2-year donation. It'll be $150,000 in total to Rupert. It gave $85,000 to the Teton Valley Healthcare Center in Driggs for the expansion of its rehab services. And then, it gave a couple other donations. I'll skip ahead. It gave $8,500 to the Idaho School for the Deaf and Blind in Gooding. And then it continues to give money to St. Luke's Health System so that St. Luke's can provide rehabilitation services in Ada County every year. So that's the charitable activities that the Elks engages in regularly. The third factor under Sunny Ridge is what donations the entity uses to sustain itself. Elks continues to rely on donations. In 2023, it received $94,000 in donations. In 2024, it received $138,000 in donations. These come from individual Idahoans. They come from the Elks kind of lodges around the state and regionally. And so the Elks continues to rely on donations. Individuals continue to believe Elks is a charitable organization and are supporting that mission. The fourth factor is the payment for services. Elks doesn't get paid by anybody it helps. It solicits people to or offers grants and donations. Applicants just have to apply. Elks reviews those, and if they meet the criteria, Elks then gives them donations. So no one's paying Elks for its services. The fifth factor is public benefit, and I hope I already made this one clear, but just to give two examples of what sort of public benefit Elks has provided. It's been an institution in Ada County, in Boise specifically, and to promote the provision of medical care to the ill, crippled, disabled. I think $8,500 to the Idaho School for the Deaf and Blind Camp is just one example. The sixth factor is profit, whether the entity earns a profit. Elks has earned a quote-unquote, I want to use scare quotes, profit the last 2 years. But I want to make 2 points on that. One, Elks's profit tends to fluctuate with the investments in its endowment fund, which are very uncertain until the end of the year, so it's hard to predict kind of what sort of profit Elks is going to make. But more importantly, Elks is a nonprofit corporation, and so it doesn't have shareholders, it doesn't have partners, no one's getting dividends from Elks. It has 3 employees, none of them are highly compensated. Salaries were just above $100,000 total on this last fiscal year for its 3 employees. So no one's getting rich off the Elks. Would you like me to briefly conclude?
Yeah, if you conclude briefly, yeah.
Yeah, and so the second factor is just, is the building used for charitable purposes, exclusively to further the entity's charitable mission? And here, all entities, or all businesses, nonprofits and for-profit companies alike require office space. The building is not leased at all. It's used 100% by Elks. It's not leased to anyone. And it's used to administer and manage the endowment fund, which gives millions of dollars. So for those 2 reasons, it satisfies the criteria for an exemption under 63602C. Do you have any questions?
Any questions from the commission?
I was going to ask you to tie the charitable activity to this specific parcel. I think you did that on your last point.
Okay, great.
Okay. Any other questions?
I guess the question, the donations and the payment for services, could you amplify both of those
The donations, yes. So,
percentages, et cetera?
the percentages.
Where you get it from and what the percentages are, and then the payment for services. You said there was no payment for services, so how does that relate in terms of the functioning of the building? Back to what Commissioner Davison was saying.
Yeah, so there's no payment for services. The building is used for just giving the employees a place where they can do their work. It's only used by Elks employees. That's where they, review applications for donations. It's where they manage the endowment fund from. The people who receive the donations, that's Elks' service. They don't pay anything for that service. As far as donations go, it was $94,000 that they received in fiscal year 2023. I think close to $140,000 in fiscal year 2024. I don't know the percentages off the top of my head. Those were in the original application. I don't believe it's a majority of what Elks's revenue is. But yeah, I think Elks doesn't really have a lot of operating expenses apart from its donations, which it gets from the income off of the endowment fund. Does that answer your question at all?
Part, I'm just trying to look at, go ahead if somebody else has a question, because I'm looking for my follow-up. But go
Well,
ahead.
yeah, the question I would have is you've got on your appeal form here, you have $3.5 million, and that's expense. And where do you get your total revenue of 5.6 million?
Total revenue?
Yeah.
Yeah, let me turn it.
Where do you get that revenue from? You said you only had donations of
So we rent
$1,000.
the Elks, oh, sorry to interrupt. The Elks rents two of its facilities that are not the subject of this appeal to other medical providers, namely St. Luke's. St. Luke's pays rent on those facilities, and that's where rehabilitation services are provided. But in turn, for receiving that rent, Elks also donates a lot of money, as I just said, millions of dollars to St. Luke's to provide rehabilitation services. So really, Elks is kind of donating, in some sense, those properties, but it does get, a large part of its revenue from that lease. The other part of its revenue comes from the endowment fund, which, as I said, is very up and down each year. In fiscal year 2023, it was almost a wash, but in fiscal 2024, the investments did well, and so we had more, and I want to use the scare quotes again, profit, but once again, that profit stays within Elks. It doesn't go out to anyone else, and it's just reinvested to further Elks's charitable mission in future years. More donations, et cetera.
Okay. So the office building because this appeal is strictly about the office building, correct?
Correct.
You have people that work in the office, and I'm trying to figure out what you actually do there, because you just suggested that most of your work is in administering the buildings that you're sort of given to St. Luke's.
No, most of what Elks does is administer the endowment fund. That's what the employees largely work on. The other two properties are leased, but Elks doesn't. That's not the lion's share of what Elks does.
But it's a lion's share of your income.
Correct. But a lot of that rent is then donated to other medical facilities.
Okay. All right. Any other questions?
Mr. Chairman, that was my follow-up was what you just were saying is the relationship of the use of the building, the income from the building, et cetera. So that was really my question as well.
Okay. All right. Any other questions? All right. Thank you. Okay. Do you have anything you want to offer?
No.
All right. Well, do we have a motion? Because apparently from the letter that you received from us, or from me actually, specifically the organization, you applied under 63602D, and now you're saying it should be 63C as well,
Can I clarify that?
correct?
Well, so we applied under two statutes, 63602C and 63602D. We're only seeking this exemption on the former 63602C as a charitable organization.
Okay. All right.
Mr. Chairman, just as an amplification in terms of the letter, reading it again, it says that if they want to appeal, if we deny their appeal, they could go to make an application for hardship as well, correct?
Yep.
Is that correct? And that would, then they would have to justify the inability to pay, right?
That's what the hardship would
As
be, yeah.
as the hardship. Okay. So we're really deciding if they qualify based on, for my purposes in analyzing it, the payment for services and as a percentage of the donations and the use of the building itself for their purposes, not rented out purposes. That's the way I view it.
Yep. Okay. Any other discussion? All right.
Just to clarify, the specific parcel we're talking about, that's their administrative office, is not one of the other parcels that's rented out to hospitals. Is that the understanding?
Well, it's my understanding, and that's where they get a lot of the revenue is from the rent from those hospitals. Is that not correct?
Yep, this is only the administrative building.
We're only dealing with administrative building.
Right.
That's all we're talking about here is just there's a separate office building, correct?
Yes, and we did not, so there were 3 denials of our 3 properties for tax exemptions. We did not appeal the other 2 buildings. We're only seeking appeal on the office building.
On the one.
The other 2 seemed to be denied because they were fully leased to St. Luke's, and those were not appealed. This building is not leased to anyone. It's used exclusively by Elks to administer its endowment fund.
Okay. All right, well, that answers the question. So the question is, because we denied the full, we didn't give a partial, we just denied the full exemption on the office building. So that's the question. Do we continue with the denial of full exemption, or do we approve an exemption? That's the question before us today. So what do we say?
Well, I'll make a motion and we can discuss that.
Okay, make your motion.
Mr. Chair, I'll move that the Board of Commissioners, sitting as the Board of Equalization, approve the appeal and grant Idaho Elks Rehab Hospital Incorporated a 100% tax exemption under Idaho Code Section 63-602C for parcel number R101-300-9181, based on the testimony and the evidence provided, and authorize the chair to sign the documents on behalf of the board.
And just as a clarification, on what basis, or what is the basis of the motion for making that motion?
The basis of the motion is that the specific parcel seems to be used for a charitable purpose, consistent with the organization's mission.
And that the other 2 parcels have been withdrawn in terms of application, that we denied, have been withdrawn in terms of they're only appealing the 1 parcel, correct?
Correct. That's my understanding.
That's correct.
Since they did not appeal those, we don't need to include that in the motion.
Exactly.
Right. Right. Okay, well,
I guess I'm sympathetic. I don't know if it's 100%, but I'm sympathetic with but I guess reviewing it and looking at it in terms of next year, I would second the motion, but with the understanding that I would like some more clarification in terms of how you're using that building, totally using that building in terms of just how you're using that building. 'Cause you say you only have 3 employees, and that in terms of your functioning, how that total building is being functioning. 'Cause I'm still not clear with it, although you've withdrawn the other 2, so I would second the motion in that context.
okay. So the motion is to approve a 100% exemption for parcel number 101-300-9181, correct?
Yes.
Yes.
Okay. Any further discussion? Hearing none, all in favor say aye.
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 Motion carries, thank you. Okay. We'll now take up Idaho Legal Aid Services Incorporated, parcel number R69075200020. Go ahead.
Thank you, Mr. Chairman and Commissioners. Good morning. My name is Sunrise Ayers. I'm the Executive Director of Idaho Legal Aid Services, a nonprofit that has been providing free civil legal services to Idahoans for over 55 years. I'm here today to explain how Idaho Legal Aid meets the 8 charitable factors set forth in Sunny Ridge. I'm going to talk fast because there's 8. That's a lot to get through, so I apologize in advance. And therefore, that we should be eligible for a charitable property tax exemption under Idaho Code 63602C. Addressing Factor 1 and 2, Idaho Legal Aid's stated purpose in our mission is to provide equal access to justice for low-income people through quality advocacy and education. This indicates a charitable purpose and function. Idaho Legal Aid is a 501c3 nonprofit that provides free legal education, pro se forms, legal advice, and full representation in high-priority civil cases. We prioritize critical needs such as helping domestic violence survivors and their children achieve safety, helping seniors recover from elder abuse, neglect, and financial exploitation, assisting families seeking guardianship, and providing assistance to veterans and low-income families in need of housing stabilization. In 2024 alone, Idaho Legal Aid closed over 3,600 cases statewide, and 769 Ada County residents received legal assistance at no cost to them. Idaho Legal Aid provides legal services to those in need who cannot afford private attorneys, and we argue this is a charitable function. Turning to Factor 3, Idaho Legal Aid is supported by donations. Our Director of Finance prepared documentation showing the direct donations and gifts, donated hours, and the donations we received from Access to Justice Idaho joint fundraising campaign over the past 3 years. Over the prior 3 years, between individual donors, family foundation gifts, donated hours, and the Access fundraising, Idaho Legal Aid received over $950,000 in donations. On average, donations from the public made up about 6.3% of Idaho Legal Aid's revenue over the past 3 years. Other non-governmental funding sources typically make up approximately 12 to 15% of our funding each year. Those funding sources include support from, for example, the Interest on Lawyers Trust account, the WCA supports us, United Way funding supports us, and other non-governmental entities such as those. As shown in the attachments provided, Idaho Legal Aid is supported by public donations, and those donations of time and funds do enable us to provide our services to Idahoans at no cost to them. For that reason, our case is distinguishable from Housing Southwest and is more similar to the facts in Community Action Agency v. Board of Equalization 138 Idaho 82, wherein Community Action Agency received some private donations, but the bulk of its funding was from federal grants. The Idaho Supreme Court in Community Action had this to say about the facts in that case. This case comes as close to the borderline in weighing factors as any that have come to this court. The court did find that by just a margin, the factors weighed against exemption, but Community Action had additional factors weighing against it that aren't present here. First, they charged recipients for their services. And second, their services were not provided to the general public, but only benefited a small pool of people living in their buildings. In Idaho Legal Aid's case, we do not charge any fee for our legal services, online forms, and educational resources, nor our public education and outreach events. Additionally, our services do benefit the general public. So moving on to that factor, our legal services such as the Senior Legal Hotline, Domestic Violence Legal Advice Line, legal clinics, full case representation are provided to thousands of Idahoans each year and are available to anyone who can't afford a private attorney. Due to our limited resources, we do prioritize assistance to the lowest income residents and those facing the most critical civil legal needs. Beyond direct legal assistance, Idaho Legal Aid devotes significant staff hours and resources to creating brochures, videos, and presentations to educate the general public about their legal rights. We also create pro se forms that are available to the general public. Any Idahoan can access our website and obtain a revocation of a power of attorney form to stop abuse by a power of attorney agent. or access parental powers of attorney to allow parents facing illness, deployment, or incarceration to name caregivers for their children. Any member of the public can watch our videos on guardianships or evictions, or educate themselves about their rights, or review our video on how to enter evidence in their case to help them be successful in court. In 2024, our rural and community outreach events put on by our staff in person across the state reached over 5,100 Idahoans. Our services do not benefit only a limited group of people, and we therefore are distinguishable from the facts in Housing Southwest and Community Action Agency cases. But even if we assumed that Idaho Legal Aid Services only benefited a limited group of people, our services are not fully funded by government tax dollars. We do have diversified funding supporting our work, and ILS's work does lessen the burden on Ada County taxpayers in numerous ways. First, representation by Idaho Legal Aid reduces the burden and cost on county courts. The clients we represent cannot afford private attorneys and would therefore be navigating their cases through the court system pro se. That increases the burden on court staff, results in higher costs to get their cases through to resolution. Whereas when an Idaho Legal Aid attorney is available to represent a client, cases are handled more smoothly and with less burden for the courts, judges, and staff. The value that Idaho Legal Aid provides to court staff is evidenced by the high number of referrals the courts send to us each year. Just in 2024, court staff referred 291 clients to Idaho Legal Aid that we ended up opening cases for. They refer even more than that. That's the number of cases we opened from those referrals. That's over 5 new cases per week we are opening for courthouse-referred Idahoans, providing services that the courts and their staff would otherwise be having to undertake with taxpayer dollars. Second, representation by Idaho Legal Aid reduces the burden for county victim services and prosecutors' offices. By providing legal support and advice to survivors of crimes such as domestic violence, sexual violence, stalking, and trafficking, we increase survivors' ability to meaningfully engage in the prosecution of those crimes. Our work with victims also reduces the demand on victim services staff and decreases their costs. Third, representation by Idaho Legal Aid reduces homelessness in our state and the costs associated with that via our eviction defense and foreclosure prevention work and our targeted outreach and representation of veterans at risk of homelessness. Fourth, representation by our attorneys reduces foster care placements and the costs associated with foster care by helping domestic violence survivors and their children escape abusive households, assisting parents with parental powers of attorney, and assisting with minor guardianship filings when parents are unable to care for children due to death, drug abuse, mental illness, or similar issues. Finally, Idaho Legal Aid Assistance brings additional income into our communities by helping seniors, veterans, and families dispute illegal or fraudulent charges or debts, ensure payment of unpaid wages, recovering funds lost due to exploitation and abuse of seniors, ensuring tenants get back security deposits they are entitled to. These funds are critical for allowing working-class Idahoans to escape poverty and be able to prosper without public benefits. In fact, in 2024 alone, Idaho Legal Aid's representation resulted in over $3 million in funds awarded, recovered, or returned to Idahoans' pockets. This is an amount that exceeds the totality of government grant funds that we received last year. Another point indicating how clearly the work we do reduces burdens on government-funded entities is how often they refer clients to us for assistance. In 2024, we opened 106 cases for clients referred by state agencies such as the Attorney General's Office and Health and Welfare, 30 cases referred by Adult Protection Services, and 332 cases open for Idahoans referred from other government agencies such as Social Security Administration, the Veterans Administration, and County Indigent Services. In conclusion, without Idaho Legal Aid, survivors seeking safety, minors in need of guardians, and seniors facing abuse and exploitation would likely be unable to receive any legal assistance and would thus increase the cost to taxpayers through increased burdens on court systems, Victim Services Office, the Attorney General's Office, Adult Protection System, and Foster Care System. The services that Idaho Legal Aid provides benefit the public, are provided at no cost to our clients, and reduce burden and costs across multiple government functions. To quickly address the final 3 factors in Sunny Ridge, Idaho Legal Aid does not generate a profit, and we are in fact operating at a deficit in 2025. Our articles of incorporation do state that upon dissolution, all assets would go to organizations operated exclusively for charitable purposes, and we do provide services based on need, requiring all clients to provide income and asset information so we can target legal services to those who lack resources to hire private attorneys. In 2024, for our 2024 clients, the average household income was only $22,000 per year, and 86% of our clients had incomes below 185% of federal poverty level. Unlike the housing providers and Community Action Partnership and Housing Southwest, Idaho Legal Aid effectively leverages a combination of public donations and non-governmental funding sources to, 1, provide a benefit to the general public, 2, provide our services at zero cost to clients and no cost to members of the public who use our educational materials and forms. And 3, we provide us services at a cost to our grantors, even that is well below market rate and well below even the cost of government attorneys. For all of the above reasons, we respectfully request that the commissioners find that we do qualify for a charitable tax exemption. Thank you.
Okay. I have a question, and that is, how much of your income is generated from a federal grant?
Federal grants make up about 81% of our income this year. And on average, it ranges from 75 to 85% of our income comes from federal grants, which are competitive grants. We don't know if we'll get them every year. We have to apply.
About 80% of your,
80%, yes.
is your, okay.
Mr. Chair,
Go ahead.
I thought in your testimony you said it was like 12 or 14% of government money made up your,
No, sorry, the 12 to 15% was other non-government money that's not donations. So like when the United Way gives us funds, we don't count that in our audit as a donation, but it's also not a governmental source of funding. Or when we get the money from the IOLTA trusts, or when we get money from WCA. So those other sources make up like 12 to 15% of our funding depending on the year. So I think we are similar to the facts in the, the Community Action Agency case where the bulk of our funding is federal grants. But unlike in the Community Action case, we don't charge for services and we are providing general benefit. And like I said, in that case, the Supreme Court said, hey, this is just on the line. And so we think the fact that those other factors weigh in our favor would put us over the line and qualify us under Sunny Ridge.
What's the line?
I'm not sure, but that was the quote from the justices in that case was, this case comes as close to the borderline in weighing factors as any that has come before this court. And the donation part we are similar on with Community Action by having a large number of federal grants. But the other factors weigh much more in our favor. We don't charge for services. We're not operating a building that only a few people have access to. We're providing services to all of Idaho.
Okay. Any other questions? Go ahead.
Mr. Chairman, the rental that you do there for the individuals, do they meet the threshold of the income, et cetera?
Sorry, which services?
The income levels.
Yes, so everyone who calls Idaho Legal Aid for assistance, we collect income information. For some case types, you have to be below 125% of federal poverty. There are some case types where we'll take over income, and those are for domestic and sexual violence and trafficking survivors. And then for seniors, those are two areas where we will sometimes take clients above the 125% of federal poverty. But the vast majority of our legal services that we provide are for low-income folks.
Because they have to be 30% of AMI, right?
No, our threshold is 125% of federal poverty. 30% AMI, I think, is a head number, but we have had grants with HUD funding that had used 30% AMI. But our largest grantor, LSC, uses 125% of federal poverty. And then we use the donations and the other non-governmental funds so that we can provide those services to folks who are above 125% of poverty and may still not be able to access legal services. The domestic violence survivors who are over income, the seniors who are over income, but maybe all of their money is going to medical expenses, those type of cases are how the donations and non-government funding are used to broaden our service scope.
Okay. Any other questions?
well, I think obviously the big sticking point is the percentage of your income that comes from the federal government. Did you get any from the state or Idaho State Bar as well?
We don't get any funding from the state of Idaho. We don't get any funding directly from the Idaho State Bar, but the IOLTA Interest on a Lawyer Trust account is run through the Idaho State Bar and the Idaho Law Foundation, and we do get funding from them each year, ranging, because IOLTA Trust fluctuates depending on interest rates. But so that amount of funding ranges from like $80,000 to $300,000 a year, depending on how interest rates are looking. So that makes up that about 15% that comes from non-governmental sources.
If you were receiving 100% of your revenue from the federal government, would you still be exempt?
I think if we were receiving 100% of our revenue from the federal government, we would be closer to the situation in Housing Southwest. And it would be, I think at that point, we would have to show even more clearly how we're not just taking government money and doing the same job that the government would do, but are saving the government money in somehow by providing those services at a cost that's lower to taxpayers, which is true for us. You know, our attorneys make far less than government attorneys make, and our services are much more efficient and cost effective than government attorneys. But, so I think if that was the case, we would have to put a lot of proof into that element, into how we're still providing a public benefit that essentially saves taxpayer dollars and isn't just moving taxpayer dollars around. And I think we can show that.
Is there any government agency at any level that provides similar services to what you provide?
Not that I think in some limited circumstances, not the breadth and depth of services that we provide, but for example, the attorneys in the Consumer Protection Division of the Attorney General's office do some of the type of consumer protection work that we do, usually for larger groups of Idahoans and not for individual clients like we do. So a little bit of similarity there. There's probably attorneys in JAG who provide similar services that we provide. So they might help deploying servicemen with their powers of attorney and wills. We also provide that service. They help with veterans benefits. We also provide those services. So there are some small cases of overlap for sure, but nobody that's doing it across the board for all types of civil legal assistance that are needed.
Okay, any other questions? All right,
Thank you so much.
Okay, did you have anything you want to add?
No, Mr. Chairman, thank you.
Okay, well, the question is, does Idaho Legal Aid qualify under 63602C?
Mr. Chairman?
Yeah.
I guess Commissioner Davidson meant, what he said is really true. It's the threshold as far as the where they get their revenue from, and it's from federal sources. And I think that tips the scale for me in terms of their eligibility for the tax exemption. So that's where I am.
Okay. Any other discussion? All right, is there a
I'm
motion?
assuming you mean it tips the scale against.
Against, correct?
It is obviously a gray area. You have to,
Correct.
you know, if we've never settled on a specific percentage of what would qualify and what doesn't.
That's also
although we've come across a couple other cases that were receiving a large amount of federal dollars, but I don't necessarily think we have a precedent on this board of how we're treating any of these cases.
No, that's yeah, you're absolutely correct. But for me, for this case, that's what.
Do we have a motion?
So I would move that the Board of Commissioners, sitting as the Board of Equalization, deny the appeal of the Idaho Legal Aid Society for parcel R6907520020, as listed on the agenda, and authorize the chair to sign the documents on behalf of the board.
Is there a second to the motion?
Second.
Okay, you've heard the motion. Any further discussion? All in favor, say aye.
Aye.
Motion carries. Thank you. Okay, we'll next take up Leap Charities, parcel number R202460985. 5985, excuse me. Okay, so, go ahead.
Good morning. Thank you for having me. Before I start talking too much, I don't want to get ahead of myself too much either. I just want to confirm that you guys received this letter. My plan would be to just provide an intro of who Leap Charities is and to read this letter, but I don't want to read it if you guys have already read it.
Okay,
Let me see here. Do we have that?
yeah, we've got it here.
Okay. It has all of the.
Dated June 1st?
This one is dated July 10th as of today anyway, but yes, it came in with our
Is it
request for
different
additional.
from the one dated?
Yeah, we have one dated June 1st, so that's why I was asking.
Okay, I'll read from this letter then.
Oh, I
Oh,
see.
no, we got it July 10th. We got that one here, yeah.
All right.
Okay.
Well, my name is Brian Woodward. I am the COO of Leap Charities, Inc. We have been in existence since 2016 as a nonprofit 501c3 creator and preserver of workforce housing across the spectrum of area median income. We're one of the youngest and most undeveloped developers in the area in the state of Idaho, but we are doing a lot of great work with a lot of partners around the state trying to address and navigate our housing challenges that we have, and in particular, those in Ada County. So thank you for granting us an opportunity to appeal the denial of property tax exemption for Leap Housing's property at 921 Shamrock Street. Shamrock Street is what we refer to this home as. We have about 15 homes in Ada County. We have requested and received property tax exemption for many of the last several years. At this property in particular, we've had property tax exemption continuously since 2021. In the affordable housing, workforce housing world, we are always subject to compliance requirements from the different funders that have given us the capital to create or preserve affordable housing. This particular home was funded in part by the Community Development Block Grant administered by the city of Boise. And in so doing, we have regular monitoring of compliance to ensure that we are sticking to all of the rules, crossing all the Ts and dotting all of the Is that are stipulated in our agreement with the CDBG funding source. This year, we were denied our property tax exemption under Idaho Code 63-602GG, and the specific reason for that denial under 602GG was we did not demonstrate that the resident residing at Shamrock Street was at or below 30% area median income. In reply, we provided in your packet a self-certification of tenant income that looks a lot like this. Folks that are practitioners in the housing world, especially those who work with Idaho Housing and Finance Association, are very familiar with this. It's a TIC, if you will, or tenant income certification. And in this certification, it demonstrates that the resident's annual income is well below the 30% area median income for Ada County for a three-person household. For a three-person household, the 30% AMI threshold is $26,500 in 2024, and the resident's income, the household's income rather, was $17,303. For this reason exclusively, we feel that the property tax exemption can rightfully be appealed and upheld.
Okay, any questions? Now, what did you say the tenant's income is on that property?
$17,303 is what the self-cert shows.
Okay, and at 30% area median income, the rent should be 30% of that amount?
The rent is governed by the CDBG or HUD guidelines for what the max limits can be.
And what would that be?
On this document, the gross rent for the unit, or the max rent, could be up to $1,605, but the gross rent for this particular unit, the tenant pays $1,125 and is allotted a $140 utility allowance.
Okay, any questions? So you're suggesting that the tenant does not need, can pay over 30% of their income?
The 30% number is the area median income threshold
Right.
that this resident falls under. The rent guidelines published by HUD do not, they provide a max limit that would be allowable.
And that allowable is 1,600?
I have 1605, yes.
Okay. Any other questions?
Mr. Chairman?
Yeah.
I think, could you address more fully because in the letter that we sent back to you in the denial, it said you did not meet all the 8 Sunny Ridge factors. So could you kind of walk through that for us?
I can, however, what we are appealing on is the statute 602 GG, not C.
Okay. So you're not claiming to be a charitable organization?
We are a charitable organization, yes, sir.
Because that's the Sunny Ridge factors are charitable qualifications. So I understand what you're saying, the C versus the, but okay.
Just to provide further
Yeah, there's
support.
code on affordable housing.
Right. I understand that part of it. But so back, I guess, did you get an adequate answer to your question on the 17,303 and the 30% question?
Well, the 30% is to their income limit to qualify, and then he's saying that the actual rent is determined by HUD to be in a range, correct?
Correct.
And that's the 1601,
Yeah.
1605. Okay.
Right. I didn't know it was determined to be a range. I thought it was a percentage of their income. but
That's
Yeah.
as well. So that's.
All right. Any other questions?
So the rent, the average rent would be in the $1,200 range on these?
At least for this particular unit, that is currently what the estimated rent is, yes.
And that's a little higher than some of the comparable ones you have, which might be around $840, $900 a month?
Yes, I earlier stated that we have about 15 different homes in Ada County. Each of them is governed by a different governing source for funding that has its own rules, including the Housing Trust Fund, Neighborhood Stabilization Program. And so, yes, that 1,200 might be a little bit higher than some of those others, especially at Wendy Court 1.
Okay. Any other questions? All right. Thank you. Do
Thank you.
you have anything you'd like to add?
I would just clarify, yeah, this exemption's only under the affordable housing, which is GG, not C.
That's right. It's GG. And that's what the application was. Yeah. And under GG, they have to be 30% area median income.
Correct.
But do they go by the guidelines of the HUD, or do they take 30% of the area median income and then 30% of their income for the rent?
Mr. Chairman, we're talking about two different things here, I guess. The HUD would be what governs what they can cap their rent at. The statute for GG basically assigns to give the tax exemption on our end, what they need to be at, which is 30% AMI.
Well, I get that, but does the statute then limit the amount of rent that can be charged?
It's unclear, it just says 30% AMI. So, yeah, I think it's up to your discretion if it would qualify as affordable based on the income, which is $17,303 annually, and then paying $1,265 a month.
Right.
That would be considered affordable under the statute.
So that would be considered affordable under the statute?
That's the question, I guess, to you, is if it would qualify as affordable under the statute, given the new information that Leap Charities has shared.
Okay. Any other questions then? All right. Well, I'll accept a motion.
All right, I'll move that the Board of Commissioners, sitting as the Board of Equalization, approve the appeal and grant Leap Charities 100% tax exemption under Idaho Code 63-602 GG for parcel number R202-460-5985, based on the testimony provided, and authorize the chair to sign the documents on behalf of the board.
I would second the motion based on the clarification that we just had there in terms of the 30% and the HUD standards. So I would second that motion.
Okay. Any further discussion? Hearing none, all in favor say aye.
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 Motion carries. Thank you. Okay, now we will take up Northwest Yearly Meeting of Friends. And the parcel number is R202-4303155. Go ahead.
Good morning. My name is Alan Weinacht, and I've been before you before. We've worked with this Whitney Friends Church property. This is what we're talking about. And I represent our church denominational group, which is Northwest Yearly Meeting of Friends Churches. And we have churches in Oregon, Washington, and Idaho. And I work mostly with our Idaho churches. So in filing this year, well, I should just give a little bit of background. The Whitney Friends Church was one that the denominational group has been working with for the last couple of years because it was going through a lot of struggles, and I wound up visiting with you a couple of times over improper filing for property taxes. They were filed properly this year but denied because said what we're doing right now does not fit with the religious purposes according to the code number given here. On rather short notice, we wound up closing this church at the end of last October, which means we were not up to speed in what we would hope to have in restarting a church. But as this year began, and it was time to file for a property tax exemption. And we have two pieces of property here, and one is the church building and one is the parsonage. And I believe right now the first one that was named is the parsonage, but the same argument or the same concern fits with both in that short term, and this is not intended to be long, we're using them just to be supportive of help people. So in the parsonage, to help the former pastor who is in transition and needed a place to live, it was willing to look over the property, kind of maintain and watch things, and in the process is working on finishing up a graduate degree in religious training, that we're simply letting her live there. And then, if I'll jump ahead to the next piece of property, we're allowing the Alcoholic Anonymous group to use that property for the church property for multiple groups throughout the week. I think the simple argument and presentation we would make in this appeal is that from our perspective, both of those fit within what churches are about because we're simply helping people. And that's fundamental to who we are. We're being supportive of people in need. We're not making anything. Yes, AA pays some rent on the church facility, but it's very minimal and certainly does not begin to cover all of our costs. And we're simply saying that what we're doing, for example, with AA or helping somebody with housing, would be respected across the board in churches and religious groups as caring for our neighbors and looking out for people. And this is not a big, long, fancy argument. It's simply saying we believe that what we're using it for fits within the range of what using our church facilities is about. And given the short timeline that we had and how long it takes to restart churches, we feel like coming into 2025, that was about the best we could do by the time this kind of paperwork was required. So that's really what I have to say.
Okay, now, are you talking on both the parcels or just the one?
Well, I'm really kind of presenting both of them
Okay.
at the same time. I understand we're talking about them individually, but it's the same discussion for
All right,
both.
same discussion then. All right, so the question is, does this parcel, is it being used for the religious purposes or recreation purpose? Is it being used for the religious purposes?
Well, from our perspective, it is, because part of our living out our religion is caring for, taking care of people, and we're simply taking care of the former pastor while she's in a transition in life, and she's helping us out, watch out over the property. So it's not a programmatic kind of religious purpose, but in terms of our ethics of caring for people, that's what we're about.
Okay, any other questions?
Mr. Chairman, just on the first parcel, the parsonage, it's my understanding that the Supreme Court has been pretty clear in terms of parsonages, is that they are designated for a specific purpose, and that's for the minister of the church usage. That's my understanding, and that's kind of the definition. And is that what this is being used for, that this building is being used for?
Well, I can honestly say it's not, because that church is not functioning right now. I have no idea that the Supreme Court had said anything about parsonages, so but no, we do not have a formal pastor living in that house right now, no. Even,
That's kind of our constraint, is the Supreme Court has been, at least my reading of what they said, they were pretty categorical in a case similar to this, that the parsonage had to be used for that purpose. It was designated, and that is use of the minister of so anyway, that was.
if this makes any difference, I can tell you what the former pastor is doing, working part-time and finishing out a graduate degree, which is going to allow her to move on and become a chaplain in the hopes to work at the VA hospital. So that's what we're using it for.
Thank you.
And whether that fits or not, I don't know, but that's where we're headed, okay?
Okay.
Okay, so let's take up R 2024-303155 first, and that's the one we're talking about, the parsonage.
Correct.
All right, is there a motion or any other questions?
That clarifies what I was, my question, and based on that understanding and the constraints we have, I would move that the Board of County Commissioners, sitting as the Board of Equalization, deny the appeal of the Northwest Yearly Meeting of the Friends Church on parcel R2024303155, based on the understanding that we have on the information and authorize the chair to sign the documents on behalf of the board.
Is there a second to the motion?
Second.
Okay, you've heard the motion. All in favor, say aye.
Aye.
Aye. Motion carries. Okay, now we'll take up parcel R 2024180. Is there any discussion or questions on that one? Now, what's the current use of that structure?
The current use is, we have it being used right now exclusively for Alcoholics Anonymous, which uses it every day of the week. So we're letting them have groups there, recovery groups.
Okay. And is that part of your religious, educational, or recreation purposes?
Say that is a very normal use of churches to have recovery groups in them. Churches I've pastored have done those kind of things.
Okay. Well, any other questions?
Is there any outstanding issues with the ownership of the church, or, which legal entity owns the church?
No, within our system, it readily transferred to where the denomination has it right now. Our group, which Whitney Friends was a part of that. And so, no, there's no dispute over ownership at all.
Okay, any other questions?
No.
All right, thank you then. Okay, we'll take up R 2024303180. Is there a motion?
Mr. Chairman, I sympathize with the situation that's here, but I don't think that it qualifies under the law in terms of the specific use for the religious purposes. So that's where I'm inclined to go, is to deny the appeal.
Do you make a motion?
So I move that the Board of Commissioners, sitting as the Board of Equalization, uphold the denial of Northwest Yearly Meeting of Friends Church on parcel R 2024303180, based on the information we have in the file and presentation today, and authorize the chair to sign the documents on behalf of the board.
Is there a second to the motion? No second. I'll second the motion. Okay. All in favor, say aye. Aye?
Aye.
Opposed?
Nay.
Okay, thank you. Okay. Now we have a couple of other AFH LLC on these parcels, and
Mr. Chair, I might add, their counsel is here, and I realize they didn't request a hearing, but since they were here, I wanted to let you be aware of that.
okay. It is parcel, we'll do R08058102110 start out with. Is that? And you are?
My name is Terry Koppel. I'm an attorney. I represent the appellant. I'm an attorney with the firm of Davison and Koppel. My address is 199 North Capitol Boulevard, Suite 600 here in Boise.
Sure.
Yeah.
Do you have the same argument for all the parcels, or is it different?
Yes, it's really an integrated whole. All 5 parcels are basically one project. And I have with me today Brady Panatopoulos, who is the CEO of the Idaho Fieldhouse and is also the CEO of the J. and Catherine Albertson Foundation. So if there's any specific questions about each parcel's function, he is certainly available to answer those questions. But I think they all relate to each other because there's nothing separate in terms of differing purpose of those various parcels.
So you want to give one presentation that covers?
Yes, I want to address the key issue that is really before this commission as addressed in its letter of denial. As the commission is aware, on the May 6th denial letter states that the request for a charitable exemption under 63602C is being denied because the property is leased. That's the sole ground that was advanced by the county. And the denial letter cites Idaho Youth Ranch versus Ada County, which is a 2014 decision of the Idaho Supreme Court that basically said under the facts of those circumstances, the exemption would be denied because rent was being paid under a lease. The facts of the Idaho Youth Ranch case is totally different than the one that's before the commission at this time. In the Idaho Youth Ranch case, that LLC was receiving $25,000 a month in lease payments pursuant to a triple net lease that existed for 25 years. In other words, the lease was a revenue source for the property owner in that case. Based on that fact, the Idaho Supreme Court ruled that under 63602C, since it was leased and it was generating revenue for the property owner, the exemption should be denied. The facts in our case with regard to the Idaho Fieldhouse project is totally different. There is no rent, no revenue being generated whatsoever by these properties. You'll note that in our submission to you, we confirm the fact that all of the expenses of the property are paid through the Albertson Foundation, through grants. None of these occupants of the property pay any rent whatsoever, or any of the expenses relating to the property. The second thing is that we want to emphasize to the commission is that even though these agreements are called leases, they're really not leases. Under Idaho law, to have a lease, the tenant has to have exclusive possession. As you will see from the leases, all of which we've submitted to you in our book that we provided to you, you'll see that all of the tenants basically have free use of the property as one integrated unit, except for the one facility that provides medical treatments, which of course has to be managed somewhat differently because of the nature of the services that it provides. Also, you will see that all of the referrals come from the foundation through the Mission 43 program outreach that the Albertson Foundation has had for some years to help first responders and active and retired military persons who have a need for the kind of counseling and maybe physical therapy and medical treatment and employment services that they offer. So I think when you look at whether or not this specific project should be denied its exemption under the Idaho Youth Ranch case, you see that it's just not the same case by any stretch based upon the facts, all of which are uncontradicted really in the record. That being the case, then of course you have to fall back and analyze the situation under the 8-factor test of the Sunny Ridge Manor case that I'm sure this commission is very familiar with. And I just want to briefly run through those 8 factors to show why the charitable exemption is particularly applicable in the situation. First of all, the stated purpose of the project. As you can see from the submissions that we've given you, the purpose of this entire project is to help first responders, active and retired service members who are in need of these specialized services. And this all came about because of Mission 43, ran by the foundation, of providing support within the community for these same individuals. And then those individuals who need special attention or care or counseling are then referred to this project by the Mission 43 program, which is really the J.A. and Catherine Albertson Foundation itself. So that's its stated purpose. Number 2, it doesn't function as a charitable entity. It certainly does. It doesn't charge anybody for anything. Its funding comes totally from the foundation that supports it. Their third factor is it funded by foundation funds? Well, of course it is. We show that in excess of $6 million a year recently was expended to support the operation. All of the buildings were, of course, funded through the foundation, through these entities. Also, the applicant in this matter, the owner of the 5 properties, is regarded as a disregarded entity for federal income tax purposes, and its activities are reported on the 990 PF tax return that's filed by the J.A. and Catherine Albertson Foundation, thereby further confirming the fact that it's supported by the foundation and by its funds. The 4th factor is, are the services free? All of the services are totally free to everyone. Even the housing that's on the property is for people outside Boise who come to receive these services at the facility. They get to stay in the facility while they're there undergoing the therapy or the treatment or whatever they're receiving. They pay nothing for that opportunity. The 5th factor is there a significant public benefit? Absolutely, because when you look at what they do, they are providing really world-class care for people in need of these services. Again, first responders, retired and active service military, and people in need. The 6th factor, is there any profit generated? No profit is generated by any aspect of this property in any way. The 7th factor is, if there's a dissolution, where do the funds go? The assets and the funds all go to the J. and Catherine Albertson Foundation because it's the one who formed the entities, and that's where the funds would go. And as I said, of course, as we all know, it's a 501c3 charity. The 9th factor is, does it facilitate a societal need? Absolutely. Again, these are people, the first responders, the military people have provided great service to American society. And when they're in need of these specialized services, these are provided, not unlike what the VA and other organizations do for them. So from our perspective, we believe that we more than meet the requirements for the charitable exemption under 63602C, and we urge the commission to go through our binder and look and see that in every aspect of this operation, it's charitable. So I would also ask that if you do have any specific questions about functions of the properties, Brady is here, as I said, to answer any questions about it, because he has worked as the CEO on this project from the very beginning up to today, as well as being the CEO of the J. and Catherine Albertson Foundation. So I'd stand for any questions.
All right, any questions from the board? Are these properties completely constructed?
The properties received certificates of occupancy, but they are still in the process of being vetted and being repaired, because on a project of more than $60 million, things were not properly completed, so construction is still undergoing. For example, the pool that was constructed is leaking, and that may very well have to be completely repaired. We also, in our submission on the exemption during construction, we listed the 10 different things that are still remaining outstanding in terms of having to be completed. Also, Idaho Power, there's an application that we've submitted to Idaho Power for credits, and in order to do that, you have to do it within certain 90 days of completion, and Idaho Power's accepted our application recently, as the project is not complete, but it did receive a certificate of occupancy.
So it's not, but it receives the certificate of occupancy, but it's not occupied.
It is occupied and being used actively.
Yes, it's been in use for, since the start of the middle of 2024. And, but yeah, like Terry said, we're still got warranty work being done, or fighting with contractors to get warranty work done to have it properly constructed. But yeah, it's being used as we speak by the Mission 43, serving the veterans and active military and first responders. Another key component of our clientele there, of the users is the Challenged Athletes Foundation, which is a separate 501c3 that is not affiliated with the J.A. and Catherine Albertson Foundation, other than we are a contributor or funder to that foundation. And that's a organization that's been around for a long time, and it's primarily provides grants to physically disabled, amputees, people with spinal cord injuries, so that they can enjoy life again with adaptive equipment, with hand cycles and sit skis and that type of thing. And so we had attracted Challenged Athletes Foundation to the state of Idaho several years ago, way before the field house was built. And we started the Mission 43 initiative way before the field house was even a thought. And as the participation and the footprint of those activities and organizations expanded, that's what really triggered the need and the desire to build a facility that those organizations could call home.
Okay. Any other questions? Go ahead.
So regarding the Idaho Youth Ranch decision, the quote from the case is, properties leased in their entirety do not qualify for a charitable property exemption under any circumstance. And so to, I guess, distinguish yourself from that, you're saying it's not the same type of lease contemplated in that case?
We're saying two things. The court emphasized in that case that, yes, it was leased, but they were getting $25,000 a month. And basically, when you read the statute, it talks about if you have business income or you're renting the property. So if you're renting the property, you must be getting rental income, okay? And so from our perspective, that case is saying if you're leasing property, you don't have to be doing anything, but if you have income coming in, we're not going to give you that exemption. So that's why they say if it's leased. What we're saying is, yes, but if there's no rent coming in and no rent is being charged ever for the lease of this property, then that case doesn't apply. I mean, the rationale of Idaho Youth Ranch, we don't disagree with, is the fact that if people are making money off their property, then they should pay their property tax. We're making no money. We're spending almost $10 million a year to support this property and provide this public benefit. The second thing we're saying is, even though these documents are described as a lease, they're really license agreements. They're not leasing any particular true piece of property. Plus, they have no control over it because the Mission 43 program refers these first responders and veterans into the system who need care. So it's not really, we should have, I guess, in retrospect, maybe called it agreement or license agreement or anything else other than a lease, but it still means that we have to have some type of an agreement to allow these kind of activities on our property that allows the owner to make sure that they are doing their charitable purpose. So the fact that no rent is paid, that in fact the owner is controlling all aspects of the charitable uses on the property, we believe that if it does wind up in front of the Board of Tax Appeals or in front of a district court or the Supreme Court, we believe that these facts are so compelling that if this isn't a charitable exemption, then it's hard to imagine what could be.
Yes, go ahead.
So you said it could have been a different kind of an agreement other than a lease. So in the lease agreement, you said that you're not getting any money, but does the lease agreement provide for any money? Or does it specifically say no money?
It says $1, which has never been paid. And you do the $1 not because it's real rent. You do that because the agreement needs consideration. Because you're going to have these entities that are doing these nonprofit work. You have to have something that's binding. To have a binding agreement, you need some consideration. So we say $1. But That's not real rent because, you know, this is a $65 million project and the rent on it, I can't even imagine what that would be per month. So it's not real rent. And so that's why the Supreme Court has said in these charitable cases, you have to look at the whole entirety of the situation. It's a fact-based, depending upon the facts of each particular case, they have to stand on their merits. And I'm sure in just hearing the cases today, this commission sees facts that are all over they go on this scale from white to black and gray and everything in between. And so the Supreme Court says you can't, when it comes to charitable purposes, it is such a broad concept that you have to use your discretion and wisdom to apply those rules. But here, from our perspective, this project is probably one of the best. It is a world-class project of what it's providing because the people at the foundation saw through Mission 43, which was an outreach of the foundation to help veterans and first responders, they saw that these people need real help, and they're not the kind of people that go knock on the door at the county or someplace like that saying, please help. But through the social engagement that Mission 43 did, they saw the people that needed help, and they realized there was nothing in Idaho or pretty much anywhere that provided this level of care and rehabilitation and help. So that's why they did it. And so that's why we feel that we are entitled to this exemption.
Mr. Chair.
Yeah.
So regarding the River House Ministries, our initial denial, I think, was because the River House is not the sole owner and the tax exempt use of the parcel was not in place as of January 1st. Do you want to address that?
Well, the property is all owned by, of course, AFH Real Estate LLC. That entity is managed by the J.A. and Catherine Albertson Foundation. Its sole member is the foundation, and Mr. Panotopoulos is the CEO of that organization and owns all of the real estate, and that's who this applicant is. Now, these other entities are all, again, owned and controlled by the foundation. So, and they are disregarded entities for federal income tax purposes. So there's no true division of ownership when you look at the overall project. And again, the only reason there are different entities, there are several entities that have unique experience, which is the Hire Heroes and the athletic organization, but you have to have different functions, charitable functions, because you have the one entity that owns the land and builds the buildings. And then you have to have another entity that manages the day-to-day activities of these activities and to take care of the property. So that's the only reason for the different entities. But they all come back to the same thing. And the leases all say the same thing, which is basically Mission 43, the foundation controls who goes there, what happens there, and that sort of thing.
Okay. Any other questions?
My question is,
Go ahead.
it's the ownership question. So is it, who is the owner of the property?
The owner.
This is River House again.
The owner of the property in this application on these appeals is AFH Real Estate LLC. We've provided you with that operating agreement. You will see that it is owned, controlled, and managed in every respect by the J.A. and Catherine Albertson Foundation. And its purpose is to construct this project and to allow these uses on the property.
Thank you.
All right. Any other questions? I guess I'm a little confused.
That's what I was trying to get the ownership question in my mind.
Yeah, well, I think you clarified the ownership question, have you not?
Yes,
But did you have a provisional tax exemptions prior? And you're asking for an extension of the provisional tax exemption?
Did you ever file for provisionals before?
Yes, I
this?
did. We appealed both of them. We
Okay,
appealed the,
prior to this year that we've appealed from, were there prior provisionals granted, or is this the only one?
this is the only one that was applied for.
Yeah.
So this is not for a provisional exemption then?
We have two appeals actually pending. One is on the 5 parcels for the permanent exemption, and then we appealed the denial of the temporary exemption during construction. So you have actually both those in front of you.
Right, and then that gives rise to the question, on the ones that are provisional, are they actually still provisional or are they completed? I guess that's the question.
As of today,
No, as of the first of the year, as
as of the first of the year, there were still pending, and that's why I mentioned the thing about the swimming pool. It was installed, it's leaking, it's going to have to be replaced, and we listed in our appeal statement the 10 different factors of the 10 different things that are not completed as of yet.
So I guess the question was, you're appealing the provisional exemption and not the actual exemption?
We're appealing both.
Mr. Chair, if I may, Mr. Koppel, think of it as you consolidate all 5 parcels, and there's 2 separate appeals here. You've got one for the provisional that's been appealed, that's before you for consideration, and you'll have to make a motion on. The second is for the charitable exemption under 602C for all 5 parcels. So if you can think about it that way, I think that's
Right,
the,
and you can make differing decisions on one. You could deny the provisional, for example, but grant the permanent exemption. So that's what's
correct.
pending.
Okay, because that seems to be clearly what we need to look at it in that regard, because it doesn't appear to me that you met the criterion for a provisional exemption, because you had the certificates of occupancy and also on so forth. So that's not a provisional exemption, correct? Would you agree with that?
I would agree that that would be a reasonable position that you could take.
All right.
But I am a lawyer, so you can only get so much out of my mouth.
Right, but then the matter is, do they qualify for the actual exemption?
Right.
That's the real question.
That's the big,
Real issue for us.
All right. Is there any further discussion or questions?
Well, Mr. Chair, I mean, I would say, just as far as the leasing question, I think there was a bar to get over that, and I think Mr. Koppel met that. I think you've adequately distinguished this lease from the lease in the Idaho Youth Ranch case. I would almost call this a lease in name only. If you're looking at the broad totality of the circumstances as opposed to just focusing on the semantics of the word lease, I think you've shown it's different or not what the Idaho Supreme Court was anticipating in their Youth Ranch decision.
Well, we need to take up the first question, which is this a provisional? And it's not a provisional, and so we need to uphold that one, and then we get into whether it's an actual tax exemption for the balance.
and Mr. Chair, if I may, procedurally, Mr. Koppel, for the chair to make the motion, rather than go through 5 separate motions, can they make one consolidated motion on each issue?
Yes, we will stipulate to that.
Thank you.
I was going to ask that question.
Okay. Well, then let's do it. Can we make one grand motion? Go ahead.
Okay, Mr. Chairman, I move that the County Commissioners meeting the Board of Equalization, sitting in the Board of Equalization, deny the provisional appeal on parcels, and I'll list these parcels and then make, and deny the provisional appeal and grant the permanent appeal on parcels, and I'll have to read all 6 parcels, right?
There's 5. Is there?
There are,
I have 5.
Mr. Chair, Commissioner Daly, if you could you make them in separate motions, please? It's going to be cleaner that way.
oh, I thought you said they could be together.
Oh, I was going to say, do one on the provisional and then do one on the
Oh,
other one.
that's why.
Okay, let's do
Because I
one.
thought you said, okay, provisional, deny the provisional appeal on parcels, So which are they then? Because there's 5 and then the River House Ministries, so which is,
The River House Ministries is not part of this matter.
okay, that's why I wanted to clarify that. So, back to the motion. I move that the Board of County Commissioners, sitting as the Board of Equalization, deny the provisional appeal for AFH Real Estate LLC on parcels R0805810210, R0805810265, R0805810275, and R0805810290, and R0805810310, as listed on the agenda, and authorize the chair to sign the documents on behalf of the board.
And those are all the provisionals, correct?
Those are the provisional,
All right.
denial of the provisional.
Is there a second to the motion?
Second.
Okay, you've heard the motion. All in favor, say aye.
Aye.
Okay. Then we'll take another motion.
I move to approve the permanent, I move that the Board of Commissioners, sitting in the Board of Equalization, approve the denial, approve the application, what am I approving?
You approve.
Or approving the applications.
Okay. Because we originally denied them, so we're approving the application. Approving the applications for AFH Real Estate LLC on parcels 0805810210, R0805810265, R0805810275, R0805810290, and R0805810310, as listed on the agenda, and authorize the chair to sign the documents on behalf of the board.
And that the approval is under Idaho Code 63602C.
And approve under Idaho Code 61 what?
63602C.
63602C. As listed on the agenda, and authorize the chair to sign the documents on behalf of the board.
Okay, is there a second to the motion?
Second.
All right. You've heard the motion. All in favor, say aye. Aye.
Aye.
Thank you.
Thank you.
Okay. We will next take up the,
No hearings, so there's no hearings on the River House.
there's, we're taking up Cuna Methodist Church, R 8069120320. And there's no hearing on that. Is there a motion? That would be the Cuna Methodist, right? Yeah, Cuna Methodist, okay. Is there a motion on that one?
Denying the appeal, correct? Or deny or accepting a number, denying the appeal.
I think this one's relating to a parsonage, which is not being used specifically for that purpose under Idaho Code.
Correct.
So our original conclusion was that the parsonage does not qualify for an exemption, according to case law, as the person residing in the parsonage is not a minister who ministers to a specific localized congregation that gathers to worship at a frequent and regular interval.
Correct.
And there being no additional evidence to rebut that contention, I would move that the Board of Commissioners, sitting as the Board of Equalization, uphold the denial of the tax exemption for Cuna Methodist Church as listed on the agenda, and authorize the chair to sign the documents on behalf of the board. And this is for parcel 069120320.
I second the motion.
Okay, you've heard the motion. Is there any further discussion? Hearing none, all in favor, say aye.
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 Okay, motion carried. Now we'll take up the North American Islamic Trust, parcel number R820-700-3796. What is the, is there a motion?
Mr. Chairman, I move that the Board of Commissioners, sitting as the Board of Equalization, uphold the denial of the North American Islamic Trust Incorporated parcel R8207003796 as listed on the agenda, and authorize the chair to sign the documents on behalf of the board.
Okay, is there a second to the motion?
Second.
Okay, you've heard the motion. All in favor, say aye.
Aye.
Motion carries.
For the, well, just a question for the attorneys. For the record, should we have stated what the issue was in the case, or is the written documents enough?
Mr. Chairman, Commissioner Davidson, the written documents are enough. That's your process.
Yeah, we're good. Okay, now the River House Ministries. We'll take that up. That would be parcel number R46715409190. Okay.
Now that, are we incorporating Mr. Koppel's arguments into?
No, Mr. Chair, Commissioner Davidson, this one is a separate application. It's submitted
Different.
by River House Ministries. It owns property in Boise with two other owners. If you recall, this is the old Armory building.
Right. And we originally denied it based on,
There was mixed ownership with a religious entity, an LLC, and an individual, and also the use wasn't in place as of January 1st of this year, which is another eligibility issue. So there were two bases for the denial.
right. And we haven't received any additional information, have we?
No, we received a letter, Mr. Chairman, he's contending that you can have mixed ownership and still be eligible. He did not address the use component.
Okay, is there any further discussion? Any more questions? Okay, well, I'll accept the motion.
I move that the Board of Equalization, sitting as the Board of Commissioners, sitting as the Board of Equalization, uphold the denial of River House Ministries based on the January 1st date and the ownership question for parcel number R4671540190 as listed on the agenda, and authorize the chair to sign the documents on behalf of the board.
Okay, is there a second to the motion?
Second.
Okay, you've heard the motion. All in favor, say aye. Aye.
Aye.
Motion carries. Okay, now we have, the next item up is a business exemption for Dairy Gold, PIDAR Dairy Gold 03. How much longer do they have on this one?
That's what I was going to say. I was going to ask that question too, but.
Mr. Chairman, I'm not sure about that, but I can ask Sherry when she gets back and we can
It
let you know.
was 2021,
Yeah,
so that's 5 years, isn't it? Or, so it's next year? I think it's a 5, I think it's a 5 year.
But you should have a draft motion in front of you. I have it
Yes,
if you need
we
it.
do.
Yeah, we do.
Okay.
All right.
I move that the Board of Equalization approve the following tax credit pursuant to Idaho Code Section 63602NN, the business tax exemption for Dairy Gold, 40% of the eligible tax credit on parcel P1DARIGLD03 as provided in the contract entered into on October 26, 2021, and authorize the chair to sign the documents on behalf of the board.
Is there a second to the motion?
I'll second that.
Okay, you've heard the motion. All in favor, say aye. Aye.
Aye.
Motion carries. All right, now we have a qualified investment exemption, two of them. Do we have a motion?
I'll move that the Board of Equalization approve the following qualified investment exemptions pursuant to Idaho Code Section 63-3029B as recommended and approved by the assessor. Dairy Gold Incorporated, a $511,627 exemption on parcel P1DARIGLD02. Photronics Inc., and $8,181,861 exemption on parcel P1PHOTRON02, and authorize the chair to sign the documents on behalf of the board.
I second the motion.
Okay, you've heard the motion. All in favor, say aye. Aye.
Aye.
Motion carries. Now we have evaluation appeal. They withdrew, correct? So we have changes, no hearing. Is there a motion?
See this?
That'd be the third page.
All right. I move, go ahead.
I'll move that the Board of Commissioners, sitting as the Board of Equalization, approve the assessor's modifications on the parcels listed under withdrawn changes and changes no hearing. Uphold the valuations on parcels listed under no changes, no hearing, and authorize the chairman to sign the documents on behalf of the board.
I second the motion.
Okay, you've heard the motion. All in favor, say aye.
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 Okay, motion carries. Now, do we have one more? BOE adjustments?
We have that.
Yeah, it's the last one.
We have, I didn't know if that was on the agenda.
Yeah, there's BOE adjustments.
I move the Board of Commissioners, sitting as the Board of Equalization, approve the BOE adjustments as listed on the agenda and authorize the chair to sign the documents on behalf of the board.
Okay, you've heard the motion. All in favor, say aye.
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 Motion carries. All right. Is there any further business that needs to be brought before the Board of Equalization? Hearing none, we're adjourned.
Time for you to get to your meeting.